My name's Eileen. I work for the Washington State Coalition Against Domestic Violence, your coalition. Thanks so much for being here. This webinar is done in partnership with our friend Tom at Division of Child Support, who will introduce shortly. But it's for advocates. So Tom and I also do webinars for child support staff, and this one is geared specifically towards advocates. So we're really excited that you're here, and we want to know all your questions, and hopefully we'll get to them. So let's get started. Okay, so what we're going to do is briefly go over Zoom. You all are pros, but we're going to remind you of a few things. Then we're going to attempt to talk about some of the terminology that Tom and I will use. And then we'll just dive in. The vast majority of the time we'll spend is on some nitty-gritty stuff around child support, sort of the whys we're talking about it, and then the hows and the whats. And then we've got lots of time for comments and questions. So like I said, I'll be facilitating the call, and I have worked on the Economic Justice Project at WSCDIV for, gosh, almost 18 years now, and have been lucky enough to work with the Division of Child Support the whole time. And recently we've been joined by policy expert Tom Atkinson. So Tom, if you want to say hello.
So long as my mute button is working, hello.
Hello. Thanks so much to Tom. So Tom and I have worked together for the last couple of years, but he's been at DCS for much longer than that and knows all the things that we need to know, so he can help us. So thanks for joining us. Before we officially get started into our agenda, I just want to acknowledge, no matter when we gather on Indigenous land. So I just want to note that and appreciate the continued culture and work of tribes and all of the domestic violence programs that are hosted at tribes, and just like the rest of our communities, and honor them for their work past and present. I am in Olympia, so I am on Coast Salish people's land and the Nisqually tribe, and just appreciate their continued presence and work in our lives. So feel free to say where you're, whose land you're on in the chat. I also just want to acknowledge that we are in week 120 of the pandemic. I know that's an exaggeration, but it feels like that. And I just know that the work has not stopped. And I just really appreciate that each of you shows up day in and day out for survivors and their children and your communities. And I just really appreciate and see the work that you do. And so I just want to remind you that you matter, not just as an advocate, but as a human and however else you show up. So I appreciate you, and thanks for being here. Now let's move on to terminology stew. So this is sort of an acknowledgement and hopefully a reminder to me and maybe to Tom that we constantly are using jargon and acronyms to talk about our work. And so this is a place to maybe upfront define some of those, and then also just remind us to take a pause if we're saying things, and for you to remind me in the chat if we're using words that you are not familiar with, because there's a whole world of jargon when it comes to each program that's administered by the state. So here are just some of them. So if there's any on here that you want to make sure that we address, please put it in the chat. But I thought we would start with a few of them that I know for sure we will use. So the first is DCS, which stands for the Division of Child Support. So in our state, we don't have a Department of Child Support, it's the Division of Child Support, and is pretty uniformly referred to as DCS. And that's where Tom works. Another acronym that we'll use quite frequently are the two, which are the CP and the NCP. And those are custodial parent and non-custodial parent. Terminology is changing over the years, and you'll notice there's a couple of other terms on here: person entitled to receive support or person required to pay support. Sometimes people are changing the CP and NCP to those terms, but for the most part, we might be referring to them as CP and NCP. So the CP is basically the person who's caring for the child the majority of the time. Another one that we'll use a lot that probably you're familiar with is CSO, which is Community Service Office, which most folks maybe refer to it as like the welfare office in their town. It's the place where people go to get benefits, to get help. And so sometimes people go there to apply for TANF or food stamps or what is called basic food. It's just a helpful place that is run by our state workers on the other side of the house from DCS, so not the Division of Child Support, but from the Community Services Division. And I realized in saying that, I used another acronym. I think this will be the last one that I define, which is TANF, which is TANF. And that is Temporary Assistance to Needy Families. So if you used to do this work back in the day, it was the thing that used to be called AFDC. Now it's called TANF with an emphasis on temporary, but it's the thing that folks can get cash and medical benefits. Tom, did I miss any that you wanted to make sure that you brought attention to?
Yes, I don't know if, I can't remember when we reviewed this a couple weeks ago, if abatement comes up later, because that one is a word that people just aren't generally familiar with. And so you should think prison, incarcerated, in jail, because just beginning February of this year, the law is that if a non-custodial parent is going to be in prison, in jail, for a minimum of 6 months, they have the absolute rights to have their child support order abated, which is not suspended. It goes down to $10 per month per order. And the reason I'd like you to know about that is because, just a guess, but there might be a higher percentage of the population of perpetrators who are in jail than the general population. And so you may have a victim who wants to know why they're getting a whole bunch of new child support stuff for the modification of an order when the non-custodial parent is in jail. And because this is already resulting in a huge number of actions to modify the support obligations of incarcerated non-custodial parents. So just wanted to give.
Great, appreciate that. We also have, thanks Katrina in the chat has asked about SEO. Thanks for bringing that up. We use that a lot. That's somebody who works at the Division of Child Support who is a support enforcement officer. And then you also, Katrina, mentioned the WSSR, which is WSSR. And that's one of my favorite. That almost sounds as good as Whiskative. And that one is the Washington State Support Registry, which we'll talk about a little bit, but it's where you can send child support payments if you want the state to log them and if you're using DCS. That's a very brief description of it, but a lot of times that's what goes on the check. Okay, so as a reminder, if there's other ones that come up that I did not define, let me know in the chat and we will go back to them because we have terrible habits of using jargon. So hopefully we can make the language a little bit more accessible. Okay, and then the last thing I'll say about language, many of you have heard this spiel before, but we know that either the mom or the dad can be the custodial parent, non-custodial parent, or the victim survivor. But we also know that the majority of custodial parents within the DCS caseload are female, and we also know that the majority of DV survivors are female. So what that might mean is that our stories, our examples may lean towards that, but it's not meant to deny the fact that many folks are experiencing violence and many folks are experiencing child support services in different ways. And so I just want to acknowledge that we understand that all genders can have and raise children, and all genders can experience domestic and sexual violence. And our examples are not meant to diminish that. Okay, so obviously you all think that it's important to know about child support because you're on this call. But why do I think it's important? So I wanted to just sort of front load. If you don't remember anything else from this presentation, I just wanted to front load why we're talking about it and what I sort of want you to hold on to. So the thing is that it's important to know about child support because it's a part of people's lives. So folks who are separating from their partners need and want financial support for their children after a breakup. And child support is sort of the mechanism that we have to make that happen. So that's the first thing, is that it's just a natural byproduct of having children with someone and then breaking up, that you have to figure out how to support them. The other big piece that why it's important is that going on welfare or TANF, like I mentioned, opens up what I call here a whole can of worms, but it really just, it grants access into a system that means that child support is going to be a factor, whether or not folks want it to or know about it. And so the reality is that many of the folks that you're working with are somehow engaged with the child support system, whether you've already had that conversation with them or not. So it's really good to have a baseline knowledge. And then finally, state programs have an incredible reach and are really important in people's lives, and have way more people access those programs than will ever come to our domestic violence programs. So it's good for us to know how those work. So that's sort of all of the information that we're giving over the next hour and a half or so is really in service to these points. So if someone goes on welfare, we want you to know what happens. If somebody's using child support to get payments, so that it's on record and that they feel like everybody is above board, it's really important for you to understand how that works. And part of that is because child support can be really helpful. So we know the research bears out, and we just know from anecdotal evidence and having eyes that when there's a steady stream of income, even if it's a small one, folks are less likely to access public benefits. And the reason why public benefits is there as a trigger is it's just the thing that lets us know that people are able to make ends meet. So for a low-income custodial parent, so somebody who's raising their children or their children are in their home the majority of the time, child support can make up a hefty proportion of that monthly income. Also with child support, a non-custodial parent can be required to provide health insurance coverage and contribute to uninsured medical expenses, which people can do without a child support order, but it's not required. And so the order is the thing that can be helpful to make that happen. Child support can also be triggered around a post-secondary education for a child. We're going to talk a little bit about court orders versus administrative orders. This one you do need to go to court for, but this can be a great help for folks that are doing anything after high school. So it's not just college, it can be vocational schools or any other trade schools. So that can be really handy to know. And is also important if you're working with somebody who has younger children. This may be something that they're not ready to think about, but it's just good for you to know in your back pocket that decisions about child support can matter after high school graduation. So you've heard all of the reasons why it's important and why it can be helpful. But the dilemma is also that, it's access to money and resources helps make survivors safer. And that's what we want. We want to give people more choices and more options about their lives and the lives of their children. But we also know that going after child support can be a huge safety risk for many survivors. And there's lots of protections, which we'll go over. But even with those, some information gets shared with all the parties. And so it's good for us to take that into account and weigh that. So the thing that I really want advocates to do, and I think is at the bottom line for us, is to provide as much information as we can about the ups and downs and then help people make informed decisions. And they get to make the decisions that's right for them. We're just here to facilitate that they get all the info that they need. So that's where I'm coming from with all this info. So one of the helpful things about partnering with Tom is that he knows the ins and outs of the system way more than I do. So it's helpful just to sort of start with, well, what actually can DCS do and what can't they do? So Tom, I don't know if you want to talk through these lists of what the Division of Child Support can do, and then if you also want to add what they can't do.
Be happy to. We often get child support orders that are entered Superior Court or even from other states. And then we set up an enforcement if the order is already existing, notify the paying parent that they are now going to be paying child support through the WISR. We can establish administrative child support orders, and I think it may still be the most common referral that we get on these are when a custodial parent opens a TANF grant. It's an automatic referral to the Division of Child Support unless the CSO has already established that it is would not be in the child's or custodian's best interest to refer it to child support. It's not very, I don't know how common that is. So it's very likely a case may be referred to us. We might get a red flag on it saying, here you go, but wait until we determine if good cause has been established. But when we do establish these, it's by notice that we mail. It's really a very different process than a court order. Court order, you have process servers, you have to show up in court or appear. They're probably allowing by telephone and Zoom these days. The administrative child support orders are really, they look really odd if you've never seen one. They're called notices and finding of financial responsibility. So somebody may be thinking they're getting a tax bill when they look at the thing, unless they actually read it. They're lengthy, and just due to legal requirements, they're fairly voluminous. But once we do those, if we get an objection, then those can go through an administrative hearing and end up with the administrative final order for child support, which again doesn't look anything like a court order. And so there, in a sense, there are three different types of court orders you can have in the state of Washington. One is a court order. I suspect you all have seen court orders and what they look like. What we call an administrative default order, or a notice and finding of financial responsibility that nobody objected to, or they might have a final order that was entered by an administrative law judge, by the Office of Administrative Hearings. We can establish paternity and or parentage. And again, if it's a case where TANF is opened, there are actually a couple of screens built in if there's DV, and we should not be establishing paternity because the non-custodial parent is or may be a perpetrator of domestic violence. We can enforce spousal support or post-secondary support. And I'll just jump into what we can't do because those are the things that we run into, the barriers. We cannot enter a parenting plan. Is a very frequent complaint among paying parents that they never get to see the kids. And it's just standard response is that, well, you have to go to court. Division of Child Support has no authority to determine which parent gets to spend how much time with each child. We cannot establish spousal maintenance. Again, that's something that the parents would have to go to court to get. We do not establish post-secondary support obligations. And so that's one that if you do have a client whose child is approaching the age of 18, you want to be very conscious that once a child turns 18, the legal requirement is that the request for post-secondary support obligation has to be filed before the child turns 18. There are some exceptions within that, depending on how the underlying order is written, but it's a good rule of thumb to think if you want post-secondary child support, you start looking into it as soon as the child turns 17, definitely before they turn 18.
Okay, great. So
And
crystal clear, right?
oh, you bet. Yeah, it only took me 20 years to kind of get a handle on it.
So the good news, if that was, thank you for that overview. If that was like, wait, what are you talking about? We're going to go into each of those things more, so don't worry. But the biggest one that we hear of confusion is this entering a parenting plan, especially for folks that maybe were working as advocates in other states, where there are some states where those things are combined, but in our state they are not. So just a good thing to know. So I did want to talk specifically about when, DCS gets involved. And the main way, and Tom mentioned this, that you might hear is this first one, that the child goes on TANF. And really what that means is that their parent, right, is accessing TANF most of the time, but sometimes it's that they're on TANF because of something else. So these are do you want to talk about any of these specific things about how that works with DCS, Tom?
I don't know if I have anything to add about the child going on TANF. That is an automatic and electronic referral to the Division of Child Support, and we set those cases up. We also have timelines, so it's very specific deadlines by which we have to start taking action. So if you have a client that goes on TANF, it would be a matter of weeks at the most before they would get information from the Division of Child Support that we have opened a case. The foster care one is one that would be a very disappointing surprise to a lot of victims of domestic violence, because if a child goes into foster care, the fact that the victim was able to keep child support from being established by the perpetrator does not protect the victim from having a child support obligation established against the victim if the child is in foster care. We go after any responsible parent. There may be other reasons to put a stop to having to pay child support in foster care, but those are controlled by the Division of Children, is a Department of Children and Youth and Families. Let's see, the court orders, they can be mixed. Some will say pay through the wizard. And I guess if you don't know quite how to handle it, a lot of them say they're payable through the wizard, but that doesn't necessarily we will automatically open a case. Because they may also have another clause in the court order that says we'll pay through the wizard, but you're not going to get a wage garnishment at this time. On the custodial parent applying for services, that's, we call those, you also refer to those as non-assistance applications, because custodial parent is not receiving benefits that would result in a child support referral. For instance, food stamps, medical assistance, if that is the only benefit that the custodial parent is applying for through the welfare office, those do not result in a child support referral, which is a good thing to know if your client is receiving food stamps or medical and assumes that they'll be hearing from child support. They will not for just those benefits. Once in a while, a non-custodial parent applies for services. This becomes a concern if the custodial parent is a victim of domestic violence. If we are aware, if we actually have a case that opened but we closed because of domestic violence, these would get screened very quickly. We try very hard. We don't always catch when we should reject an application. But we do have some non-custodial parents who apply for services. Don't really have anything to add to another jurisdiction asking for services, because they get their referrals the same way we do within their state or country, either because of welfare or a non-assistance application to those child support agencies. And then somebody can ask for information in our records. You usually have to be an authorized individual to get those records, and we can cover that more in depth. I don't remember, Eileen, if we have a slide on that. I guess I'll touch on one area where we can get a request is that we will allow a non-custodial parent or a custodial parent to request income information of the other parent. We don't necessarily have to have a case open. But the only thing that person will receive if they do qualify for the information is they will get a summary of income that we have access to, usually employment security records. And we do not disclose employers, addresses, anything regarding locate information.
Okay, great.
But there are lots of other types of public disclosure or child support record disclosure information as well. That one's just kind of a one-off that we kind of created the process to accommodate people.
Okay, great. Thank you. And I just wanted to highlight too that people often are thinking about child support for the folks who are going on TANF or accessing services. But I have noticed over the years that if you're, one of those, what Tom was saying, a non-assistance case, the custodial parent applying for services or the non-custodial parent doing that can be helpful when there's a lot of contentiousness and they want just a record. They want someone else to be sort of the third party who's noting if the payments are going through. That can be a really helpful service that DCS provides. And we also know that certainly—
Eileen?
Oh, sorry, go ahead.
Oh, no, I just, when you're done, I wanted to respond to the last comment in the chat.
And then I also just wanted to note that we also are, fully aware that many survivors and victims get their children, lose custody of their children as a result of domestic violence. And so having a non-custodial parent be able to apply for services can be helpful. There are fewer protections, which we'll go over for NCPs, but they still do exist. So we'll make sure we cover that. And yeah, thanks for noticing the question in the chat, Tom. I'll just kind of kick it to you, which is, what if existing child support order says that a parent agreed to not seek child support after the sale of marital property, like a house, etc., and one of the parents applies to TANF? Would child support still be ordered? And would the person applying to TANF still qualify?
I'll touch on the TANF. The person applying for TANF will qualify for TANF regardless. That they don't base the eligibility for TANF on the terms of a child support order. The rest of it, I'll give you the standard legal response, and that is, it depends. One thing that has really surprised me, I've been with the Division of Child Support since 1994. I am still surprised that I see terms in court orders that I have never seen before. So if you are involved in assisting a victim get a child support order, you want to be real cautious of terms you put in the order that make child support contingent on anything. We have to sort through these and sometimes figure out whether there is something in there that we can separate from what should be child support, because we do not enforce property settlements either. And I'm glad you brought that up in this question, because sometimes there will be clauses in child support orders that will reduce the amount of child support once a non-custodial parent pays off a judgment, or even a judgment against a custodial parent that's supposed to slow down the time that child support is supposed to start. And so my answer to this is that I would have to see the specific order to tell you what child support can do with it, because they can be all over the board. But if the child support is going to be contingent on something else in the order, then that can cause real problems for us to enforce the child support provisions. But this might be a question, Eileen, that you could, ask somebody who works at CSD. I'm not aware that any child support order has any effect on a receipt of TANF. The property settlement divisions may, because they might be considered an asset that they consider when determining eligibility.
Okay, great. And we've got
Daniel Holt just answered.
Yeah, thank you so much for that. And that was going to be my sense. And Daniel, if you want to elaborate, but my sense is that TANF has its own, processes and procedures that are totally separate from a child support order. So once you go on TANF, you have to, there's rules and regulations that are related to that aren't going to be, particular to a certain order. So hopefully that helped, Stephanie. Thanks for the question. And feel free, that's a good reminder to folks to continue to put questions in the chat. My preference is to use the chat function rather than the Q&A, just so I don't have to look multiple places. But we did have a good question in the Q&A that I want to just highlight, which is Annie's saying, isn't it true that TANF will end after 3 months if the child support payment is more than the TANF amount? As far as I know, it's not necessarily 3 months, but yes, the TANF amount will end if the child support payment is more, for sure. That'll definitely happen. And that's a challenge because 1 month of child support payment can be high, but then if the person doesn't pay regularly, that's a real issue. And that's a way that that folks that are, trying to control and coerce their partners, can use that, where they'll pay 1 month and then won't pay, just to sort of disrupt their life. So, okay. So I'm going to say that I answered that. Perfect. Okay, great. Good questions so far. Oops. Oh yeah, here we go. So, so we've said get involved. What does that actually mean? So, Tom alluded to many of these things, but if you want to highlight any of these things in particular, like the abatement thing comes up here, and any of you mentioned locate services before too. So if you could elaborate on that, Tom.
Yeah, if you can request the location of the other parents, and I have to be honest, because I haven't run into a case where we do locate without opening a case. I'd encourage you to go ahead and ask. We can receive requests from other jurisdictions asking us to see if somebody is located within our jurisdiction. I think I just used the wrong word. And it's the laws get real involved. It's just we don't see many cases where just a parent is asking where the other parent is when they don't already have a case open. But should you run into that situation, by all means, contact me. There may be something we can do. I think we've covered the payment processing. To me, that gets more, that involves a little bit more about where the payments are going, the names that are on the payments. I think we do get into this a little bit later. A victim changing their name or wanting to use the name that they had when they knew the perpetrator, even though their name may have changed because they got a court order change their name or their marital status has changed. And the support over modifications. Sorry, I'm just kind of rambling here. I don't know that I have anything else to add to any of these unless questions have come up for anyone on the presentation.
Okay, great. I think we're good. I think there was a question about international collaboration, but we'll get to that later. So hopefully I answered it okay for now, and then we'll keep going. So this is my public service announcement slide that I just want to really remind folks that DCS is really good at their job. So over the years with different technologies and different tools, I just want to make sure that you all know that DCS is really good at finding people. Even if the survivor thinks that they're working under the table and that they'll never be able to find them, there's so many computer interfaces and automatic referrals and automatic uploads of data that you just can't actually bank on that as a safety strategy. And so my suggestion is always, if somebody is concerned about the safety of DCS finding someone, we're going to talk about the protections. They should incorporate those protections into their safety plan rather than relying on DCS not being able to find someone. The other thing that Tom mentioned earlier that I don't know if you caught was that he said there were time periods that things are required to happen. There are lots of federal regulations that then trickle down to the states that make, again, DCS really good at moving quickly and doing what they're supposed to do in a short period of time. So again, you can't rely on paperwork getting lost in the mail because everything's electronic now, and they know all the things before we even think about it. And the other thing just to note is that DCS can use lots of different tools at their disposal to get an NCP to pay. So for example, they can suspend hunting licenses, they can seize property. There's all sorts of ways to get somebody to pay or to get really angry, right? So it's just really important to know that. So speaking of that, in terms of what we call, this is a nice euphemism, a bad reaction, there are things that you can do. So for folks that are non-assistants, remember this is what it means when people are not receiving TANF. So they've chosen to interact with child support on their own. And the nice thing about this is that then it's up to the survivor to decide if it's safe or too risky. So if they're using DCS services, but they've chosen to do that because they're non-assistants, they can actually just close the case and stop using it. They can also use an alternate address. So if they are using ACP, great, or they could use something else. And if the CP thinks it's too dangerous, they can just go ahead and close. It's a little bit trickier if it's the NCP, but there are measures too. And yeah, thanks to Anka for mentioning, that DCS can also interact with passport renewals. So, and then it's a little bit different for folks that are accessing TANF. So again, these are folks that didn't necessarily choose to interact with DCS, but because they are receiving TANF, which remember is temporary assistance for needy families, there's a few things that folks can do. So they can use an alternate address if that's something that's helpful. But the biggest tool that you have, and so this is like, again, if you're going to take nothing else but this, that the words to know are good cause not to cooperate with DCS. So my big advice on this is if you're working with someone who has not gone on TANF yet, so this is like, the ideal picture where someone has not accessed TANF services yet, then this is great because you can tell them that when they go in for their very first interaction, they can claim good cause or they can bring it up with their worker. That's like the best because then it's from the get-go that they are in this process. That said, you can claim it at any time during the time that you're receiving assistance, even after the TANF grant has closed. So good cause is determined by the staff at the CSO, not child support. So that's the other really tricky thing about this, excuse me, is that people think about, well, this is child support. Child support's contacting me. I should contact child support to get it to stop. Ultimately, CSD staff, which are the staff that run the CSO, they're the ones that actually are in charge of this process. So it's a little bit confusing. So again, that's why it's super helpful for advocates to understand this process because you can help somebody through. So you want to, again, equip survivors who are concerned about either a bad reaction to child support beforehand or it's already happened, that they can get good cause not to cooperate with child support. And I'll talk further about how to do that. The other thing I just want to say here is that the words are super important, good cause, and they have lots of different meanings at the CSO. So it's even better if you can say good cause not to cooperate with DCS, because then it's really clear that you're talking about child support, not about the other kinds of good cause, which I won't get into because that's a whole other rabbit hole. So how to claim good cause, like I mentioned, talk to CSD staff at the time of application is like the dreamiest scenario, but later on is okay too. The actual form that survivors need to fill out is this form here, the 18334 form, which is called Your Options for Child Support Collection While Receiving TANF or Medical. It's a little outdated because medical isn't triggering child support right now, but what you need to know is that it's 18334. When they fill out that form, here's the nice thing about that form is it's one page. Yay, I love a one-page form. So that's really good. So it's pretty short. And all that they need to do is they have to survivors have to state their fears and concerns about child support collection and sign it. So you don't have to get police reports. You don't have to get somebody to say, yes, this is true. You don't need a certification. You don't have to have medical records. It's basically like an affidavit saying, I'm concerned about the safety of me or my children if you collect child support. You don't have to go much deeper than that. You don't have to tell the whole story. Survivors get to decide how much to share as long as it's clear that their fear and concern is about the safety of them and their child. So if you fill that out, there's two different kinds of good cause that can happen. The first is good cause level A, and the vast majority of people are requesting this because what this does is it closes the case, which means that DCS doesn't work it and that they stop anything that they're doing on it immediately. And then they won't reopen the case unless the custodial parent affirmatively asks for it. So they withdraw their claim or they're off TANF and then eventually later on they apply for non-assistance services. The big thing is that my preference is that cases don't get opened at the beginning. And so that's super helpful, why it's nice to do it upon application. But if a case is already opened, it'll be closed for good cause level A. The other thing it does is it triggers these protections around if the NCP requests for the CP's address, so for the custodial parent's address, that's denied automatically. They don't have to go through a process, it's just automatic. And then if an NCP applies for services on their own, those will be denied as well. Anything else I'm missing on this, Tom, that you want to add?
It's like my mind is moving, but it's nothing specific is coming to the fore.
Okay, good. Well, hey, I'll take it. So then let's move to good cause level B then, which I just want to share, like I was kind of thinking red light and then the good cause level B is the yellow light. And so, sorry, I keep messing with my mouse. The good cause level B means that DCS does continue to work the case, but they don't require participation from the CP. So again, the survivor. They let them know what's happening, but they don't require them to fill out any paperwork, show up at any hearings, anything like that. And then it also has the same level of protection around the automatic denial. So I do have this little note that good cause level B can impact paternity cases. And this is like where it gets really in the weeds. But the main thing to know is that sometimes paternity cases have already been referred to the prosecutor, and the prosecutor may not stop. They may still continue with paternity, even if the Division of Child Support is saying we're not working on this. And so that can be a tricky thing and can be sometimes a place of advocacy where, if you're working with someone and this is an issue and that's going to put them at risk, where potentially, your advocacy could really make a difference with the prosecutor's office. What else do you want to add to this part, Tom?
Yeah, on the paternity cases, in my experience, if the custodial parent simply ignores the prosecutor, there's really no repercussions. But if they haven't, it's like the good cause B is of course determined by the CSO, because and I don't know what the criteria are, but the level of risk isn't as high as level A. So somebody's determined that there's not that great a risk to the CP to be involved in child support. However, I've seen a number of cases, and I'm sure I have not seen anywhere near all of them because I'm not involved in that. But I've seen a number of cases where the prosecutors do post case notes in our computerized management system, and they will make several attempts to get the custodial parent in for interviews, blood tests, whatever is needed. But ultimately, if the custodial parent simply ignores them, then it will be referred back to the Division of Child Support, and all we can do at that point is close the case.
Okay,
so we don't question why a CP may or may not cooperate, but if it's a cause level B, we will make all the efforts we can without coercing the custodial parent to cooperate.
Okay, great. And the other thing to know is that good cause level B, this is a narrow portion of folks out there, but it's good for folks who are with a partner maybe who respects the fact that they're not participating, but that the state is doing this thing without them, right? So like there are some people for whom that makes a difference, but it's a small proportion of folks. I will say that good cause level B can be nice if child support is going to be safe. It's safer, right, to do it this way sometimes. And it also we're going to talk about the pass-through. It makes the pass-through possible because child support can still be collected. And it sort of has a little bit of a baseline where somebody gets used to paying. So it can be a nice option if it is safe for you to say, hey, I'm not doing this, the state is doing this. So a couple questions in the chat. I think this was about the good cause form, and is there also an interview option? Quite often, those forms are associated with your interview. I think you do have to fill out the form, but if that becomes an issue around language access and things like that, there are lots of alternative options and help you fill out the form. But you do have to submit a form. And then another question that we'll get to a little bit later, which is what happens when the survivor is the NCP and what protections are there. So the most part, the protections are going to be address related, and those do exist, and I'll give you the particular protections and the links to those. But ultimately, NCPs who are the survivors are not as entitled to as many protections, but hopefully it also means that they don't need them as much, because if they have their address protected, that goes a long way. The harm of having to pay for children that you've lost custody of certainly cannot be repaired. And so that piece is certainly not there, but there are protections that exist for things like addresses. So hopefully that helps.
Eileen.
Yeah.
It's just dawned on me, it's like the most common scenario where the NCP may be a survivor is probably a foster care case, where we would open a case against the victim because the child's now in foster care. One thing to keep in mind is that each parent, unless they are married and residing together, will not have the same case for the same child. We open a separate case in foster care for each parent and each child, so that the perpetrator, who would be their NCP on their own case, they would have absolutely no rights to any information on the victims, the survivors' foster care case. When it is something like a non-assistance case or a TANF case, yes, we can highlight the cases to prevent address disclosures, so long as we are aware that the NCP is the survivor. Our support enforcement management system, our computerized system, is set up so that we can code any individual in a case as being the survivor of DV. Could be NCP, CP, or any child.
Okay, great. Thank you. So sometimes it happens when somebody's applied for good cause, but then their TANF case actually closes. And again, it's just important for advocates to know, like, if this is the case, we all want, it's better for everybody if CSD closes the loop on that. So there are policies that say that even if a TANF grant closes before the determination, CSD will still make that determination, and that the Division of Child Support will wait on them. And so sometimes they have to bug them and poke them and say, hey, what happened with this? But for the most part, hopefully those determinations will still happen, so the protections will last even after the TANF grant closes. So most often, if somebody is putting in a good cause claim and they've said that they are concerned for the safety of themselves or their child, it gets approved. But every once in a while, there are good cause claims that get denied. So if the claim gets denied, the main thing to know is that a custodial parent can always ask for a hearing, and they have 90 days to do that. So sometimes denial is based on, it's just paperwork misfile, so they actually didn't mean to submit the form. So it's really a withdrawal, but they marked it as a denial. Or maybe they didn't follow up and finish what they said they were going to do. So it's just good for you to know that if someone gets a denial, it's not the end necessarily. They can always appeal within those 90 days. And then DCS will always wait the 90-day appeal period. If for whatever reason the denial really was based on that withdrawal and the CP is like, oh no, I didn't mean to do that, I really do want you to start working the case, they can call DCS, and then what they can do is work with them to actually file a written request that says, you know, this was an error, please do go ahead and work the case. It's pretty rare, but sometimes it happens. Okay, so I think that before I move on, that's sort of like the ins and outs of the good cause process. Any more questions about that? Or Tom, did I miss anything that you want to make sure that we say?
When you mentioned that if it's something where they did not mean to withdraw, I agree, they can contact DCS, but ultimately it is the CSO that makes the determination. So we will probably actually refer you right back over to the CSO. We can give some guidance, but it is the connection with the CSO that makes or breaks the good cause.
Right, great. Okay, I'm going to keep moving on, but feel free if there's anything that you want us to cover again to put it in the chat. So we mentioned this briefly, but you know, some folks are going to the CSO to get medical assistance and not TANF. So they're, what we call it, the fancy name is MAO, medical assistance only. And because of some certain changes in the federal law and all of those things going together, I'm making hand gestures, you can't see them, but I am. Right now, opening a medical only case will not result in a DCS case. So instead, what often people who are getting medical assistance only, they'll get a letter that says, hey, just so you know, child support services are available to you. But for now, they're not required. This has been in the works to change for a long time, and it just hasn't. So we're paying attention, and we'll keep you posted if it does. Similarly, with childcare, or DCS calls it daycare, there is also not a requirement that folks that are getting subsidized daycare get child support services. There was a short period of time where that was the case, but it went away. And even during that time, there were good cause exemptions, and DV can be one of those reasons. There's other reasons as well. But for now, it's similar to medical, only in that there is no requirement to participate with DCS. And again, it's just important to know this because you want to know, you want to give survivors as much information when they're going to access services, that they know what will happen to them and their information. And then Tom mentioned to me that just in case you were curious, provider's information is not disclosed to another party unless a judge orders it, or the CP says that it's fine. So just important to know too. And then we talked about, oh yeah, go ahead.
Some of the things that just dawn on me as we're going through these. One thing to keep in mind is that if we are enforcing child supports and the custodial parent survivor is getting subsidized daycare, regardless of it's subsidized, there is often a healthy copay, and the custodial parent can ask us to add the non-custodial parent's share of that copay to the child support. So even whether the child care is being paid for out of pocket or subsidized, the amount that's being paid for by the custodial parent can be worked into the child support obligation.
That's super helpful. Thank you. Okay, we refer to basic food or SNAP, to food stamps, which often people say, but the correct term is basic food. And again, similarly, there is no requirement that you apply for DCS services or that DCS gets involved in your life. There has been a lot of efforts by other states to combine these, and so many states do have that. So that might be a shift for advocates who've worked in other states or for survivors who've lived elsewhere. But here in Washington, they are not linked yet. Just so you know, if folks, put bills in and try and make this happen, we'll for sure make sure that there is good cause, and we'll also let you all know as part of our advocacy for policy. So stay tuned. But for now, it is also one of those things that you can get without any connection to DCS. Okay, but in terms of a bill that did pass, for those of you who've been tuning into these for a long time, we always have this slide and we say, well, this used to happen and maybe it'll come back, but it hasn't yet. But it did happen and it is back. So that's super exciting in some ways. I'm sure Tom probably has a different feeling about it because it's a lot of work for DCS folks. But I really appreciate it because it is money that DCS can pass through to families who are receiving child support. So the bottom line around this is that for folks who are on TANF and who child support is actually able to collect money, DCS can pass through up to $50 per month for a family that has one child, or up to $100 per month for a family that has 2 or more children. Now, the main thing to know is that they can only pass through money that they've collected. So if they're able to collect $25, they can pass through $25. They're not going to pass through more than they've actually collected. But it can be really, really helpful. This is extra money that is not counted against your TANF grant. And we know that the TANF grant is really, really low. And so it's more money that helps people buy groceries. It might actually help buy a birthday cake. If one of the kids has a birthday that month, it can help with school supplies. It can, it's just more money going into survivors' pockets. And so it is happening since February of 2021. Again, this is another benefit of the good cause level B. So you get some of the protections, but child support is still collecting. That's what I wanted to share about this. Any other from the DCS side of things that you want to share about pass-through?
Um, yeah, just like I liked your comment about how we feel about it. We have to really put on our tunnel vision about what is good for families.
Yeah.
The pass through is an incredibly labor intensive item when we run into issues. I will point out that a lot of collections we make, as all of you may be well aware, is through um, IRS income tax intercepts. We can collect those from the non-custodial parent. Those are not something that will be passed through. Those can only be applied to debt. So we do get a lot of issues sometimes where a custodial parent finds out that we collected some money and say, hey, wait a minute, I didn't get any pass through that month. There may be reasons that we collected something in a given month, and they can call and ask, rather, if they want to ask for a hearing, we certainly end up with a lot of hearings on these, and we're not going to prevent them. But if your client has a question about why we didn't, share some of that collection, there very, very well may be good legal reasons. The federal law does not allow us to share that tax refund intercept as a current support payment. And so that's all I wanted to add to that.
Okay, great. So I think that is a little bit, again, like Tom knows way more than I ever need to know, maybe even want to know about this. But the main takeaway that I would say is if you're working with someone who has questions, DCS is really great about answering the whys and the hows of those things. So we're going to give you Tom's contact info at the end. You can certainly reach out to him, or you can connect with your local DCS folks, and they can help you understand what's going on there. So someone asked in the chat around how child support is determined. And so I'll just say that we do have a child support schedule. I will find that link and put that in when you get the PDF of the presentation. I'll make sure that you can see that. As far as I understand, Tom, you can tell me if what I'm missing. People can determine, sometimes people go off the schedule, but you also don't have to follow it. And so it can really vary, and every state does seem to be different.
Yes, what one state does is not going to be what another state does. Some of us may have identical child support schedules, but I don't know if anything have exactly the same. But in Washington, it is based on the parents' incomes. Although we try to use actual income, there are times where someone's historical income may be used. So there's no way I would automatically run a worksheet and say, yes, this is what the child support amount is going to be. There are a lot of factors that go into determining what each parent's income is.
Great. And then Mary's asking in the chat too about what about the NCP taking stimulus money? So I think there's sort of a couple of answers about that. One is child support related, and then one isn't. The one that isn't is certainly that we've heard that that's definitely a mechanism of economic control that folks that are, trying to harm their partner are using. There's other avenues around that might be, legal advocacy and trying to figure out if there's avenues in terms of dissolution and things like that to deal with that. But in terms of the child support, I don't know if you want to get into that, Tom, around how you all handled sort of the first and second rounds of that, because it sounds like you had to do two different things.
All I can say is that virtually everybody in the Division of Child Support is happy that what we had to deal with the first round is pretty much over. We were allowed to intercept that from the first, whatever amount was owed for child support up to the amount of the stimulus payment. And it wasn't a simple thing. It was ugly. It involved the involvement of almost everybody in the Division of Child Support, from people who were simply doing the collections of child support, people who were determining whether we should return some of that money to a non-custodial parent who had a hardship. We even had hearings come out of it because we did or did not intercept a given amount. The second and third stimulus payments are not subject to child support intercepts. In fact, we're having some discussions right now whether if we discover that we have garnished a bank account where the stimulus money went in, whether it should be returned to the person whose bank account that was. And I think we're leaning in the direction that we will try to treat it as non-garnishable, even if it's gone into a bank account where it was not initially deposited. As far as whether that is income that is used to calculate the child support obligation, I can only say I don't think so, based on the way the federal government is treating it as not income. All I can suggest is that if you're in the middle of trying to establish a child support obligation and you're aware that the non-custodial parent received the stimulus, bring it up and let the people who are determining what the obligation should be aware that the stimulus payment was granted.
Okay, great. So feel free if there's any other questions that are coming up for you so far. I'm trying to answer some of them in the chat. I think we've gotten to those. Let's see. So someone's asking. Yeah, so we're getting a little bit into the TANF weeds, but I can answer this one from Anka around, do survivors still have the protections that TANF will not be counted towards the lifetime limit, and what level of proof is required? So there is still within, and this is something I would definitely encourage you to tune into any of Tracy, my colleague Tracy at Wiskative. She focuses on the other side of the house from child support around the community services division. But for now, we do have what are called TLEs, so time limit extensions, that domestic violence is a reason for. So you can still definitely get exceptions to the 5-year limit that TANF has. At this point, I am not totally sure of what the proof is required, but most often you do have to sign a form, which is similar to an affidavit. And there is definitely not a requirement that you have police or medical records. I'm not sure exactly what that is, but I can find out for you. And again, Tracy, I'll put her email in the chat box, but Tracy at wiskative.org is who is sort of our TANF guru on staff. Okay, great. Any other questions you have, feel free to add them. Let's move on to this part, which actually goes to the question that just came in. So we'll get to this in a couple of slides, Gloria. I just want to give folks a heads up that when you have good cause level A, DCS doesn't work the case, but it doesn't necessarily mean that the NCP doesn't owe child support. So like I said, if you get good cause level A after you've applied for TANF and the process has already gone, a child support order may have already been established. And so if that's the case, the debt can continue to accrue even if DCS isn't working it. So it's just good to know that this could be something that could hit the NCP later on. And just in terms of your safety planning with folks and your awareness of what the context is for their lives, it's just a good thing to give people a heads up on. Tom, did you want to add anything about this part?
Yeah, okay, yeah, no, you pretty much covered it. Sorry.
I mean, everything is
Eileen?
But yeah.
I need to step away for about 60 seconds. I will be back as soon as possible.
Okay, no problem. I can carry on for the next one. This slide, do not look at it because it's ugly, but it is great in the PDF because it has all of the RCWs and WACs that are the protections that we were talking about. So mostly it's about addresses, and then the first one is about the very broad confidentiality requirements. So just be aware that you have access to that. So if something's coming up that doesn't sit right, it can be helpful to have the WAC in front of you. And it also is just a good reminder. I love how the WACs are written, that they're in question and answer form. So it's usually a little bit easier to understand than those really long forms that can be very intimidating. This is another good reminder. Tom mentioned the language that is used in those letters that people are getting quite often from the Division of Child Support. And they're really, I find them very confusing. And I'm not super stressed out about it. So imagine how confusing and stressful it is when, it's actually about you and you're getting it. So this is my other PSA or plug, that if you're willing to help folks read their mail or open their mail, that can be a really huge advocacy strategy to make sure that people are understanding what is required of them, what role they can play, and what their rights are. So in terms of more address protections that aren't necessarily in the WAC, one thing to know is that if you're working with someone who is getting their health insurance through the NCP, you can actually ask to use the child support headquarters mailing address on any forms about that health insurance for kids. So that way the NCP or the union or whoever's sort of in charge of that healthcare doesn't get the child's address. So that can be super handy, just as a blanket kind of big picture protection. The thing that it doesn't do is it doesn't necessarily deal with the statements that come to somebody who has the health insurance. So I don't know about you, but my mailbox is often full of those EOBs, the explanation of benefits, that are like, oh, you went to this doctor on this time and you had these labs done. Here's how much insurance covered and here's how much you have to cover. Well, those statements often have your name, the doctor's names, the addresses, the dates of treatment, all of those things, which can be very helpful to somebody who's trying to track you down or trying to get your schedule or just trying to get a picture of what's going on. So it's just important to know that that's the case, so that, using the, address of headquarters can be helpful, but it doesn't necessarily prevent them from understanding what services you're providing. The other thing we know is that folks who are trying to control and coerce their partners can turn anything into a fight, can turn anything into saying that you're unfit. And so, health information is very sensitive. And so that can be used in all sorts of dangerous and unhelpful ways. So Gloria asked, does Child Support Agency work with the IRS to verify income of the NCP who reports to be self-employed? I don't know if Tom's back for that, but I will say one of the things to know is that every employer has to do a federal reporting to child support. So even, me, when I got my job at the coalition, part of what they do is they send that information to child support, the federal office. And every employer is doing that. So there are things that are happening that we don't even, I never knew that happened. So there are things that are happening that are just automatic referrals and automatic transfer of information that are just good to know. So a self-employed person has to do something, whether or not it is legit, probably depends on the integrity of that person. I do know that there is some conversation between IRS and DCS. I'm not sure around how much that is. And so Tom hopefully can speak more to that. And someone's asking, oh, perfect. And then I don't know the answer around Uber and Lyft, but I assume so. But I don't know if you have more to say about that, Tom.
Actually, on the working with the IRS, we do what the IRS tells us to do. We do not get income information from the IRS. The only thing we get from the IRS that gives us a clue as to whether the NCP had income last year is if they have a tax refund that we can intercept. But the IRS does not provide income information to us. I'm trying to think there was another part of that. All income, although Eileen, you're right. As far as income that is reported, I don't know that people who are self-employed have their income reported to what we call the Federal Parent Locator Service, where we have access to employment security data from other states. And other states are not necessarily really good about recording and providing that information to us through this portal we have with the federal government. As far as the Lyft and other ride services, I'm not aware that we have access. I'm not aware that they report their they're not employees at this point. I'm not aware that they report their individual drivers' incomes to anybody but the IRS. Most employers who fall under the eligibility criteria reports to the state, so that employment security then has information, and those that report to the federal government, some of those are available through this national data for new hire site through the Federal Parent Locator Service. But although we have really good information available, we do not have information available for everybody who holds a job.
Okay, great. Thank you. Okay, so we're getting to the part around interstate dealings, and then we're also going to talk about international after this. So the main thing to know is that states are constantly talking to each other about child support, and there's like very specific rules around how they do that. The main thing around like protecting people's data and addresses and all of those things is that I have a lot of confidence in Washington state, and I have less confidence in the other states just based on what I've learned. We're really lucky in our state that we have great partners at DCS who have really prioritized confidentiality, but it is something just to know safety planning wise that this can be a concern. And so it's really good to, check in and see what folks are doing and what they're concerned about to find out if it actually is protected. But Tom, do you want to talk us through specifically how this all works?
When we send a referral to another state, we do have to have the custodial parent provide some information to testify it's on the form that they are the person who is entitled to receive the support. Part of that is the requirement for their address, contact information. But if they will complete the non-disclosure form, then the other state is required to keep it confidential and not disclose it to the other parents. And I guess if you have a case where that your client is getting ready to complete those forms, you can keep in mind that Division of Child Support cannot disclose information to another state that we don't have. So if your client is using an alternate address for them, they may have to make sure that they will actually get their mail there. But if the address on our file says that they're using the address, a care of address, we do not force them to disclose to us where they're actually residing. So as long as their address is protected with our internal mechanisms, then that would be the same information that is forwarded to the other jurisdiction, just in case somebody at the other jurisdiction misses the non-disclosure finding.
Okay. Well, then let's move on to the international things. And what I've sort of gathered on this is that it really depends on the country. And so things work differently. And so there's some that have these like reciprocal laws, and then there's these Hague Convention countries. And Tom was just telling me that DCS is currently working on this new thing with Canada and Mexico. So I don't know if there's some generic information that you want to share about that, Tom, but how does that all work?
Do we have 6 months? They're basically the same as referring a case to another state. They get a lot more complex because the majority of what we are doing with other countries right now, actually with the exception of Canada, because we probably have most of our intergovernmental or international cases with Canada, but it's like kind of generally we use the same forms. Some countries will require that we provide certain information or use specific forms, but the Hague Convention they're the biggest group of cases for international cases. And my understanding is that if the non-custodial parent fills out a form, the non-disclosure form, we simply tell the other country, you're not going to get the address. You work through us. That's my understanding. And so I should look into that. It's one of those things where it's like, that's always been my understanding. I've had no reason to go find myself wrong on that point. Mm-hmm. The treaty countries, I guess Canada might be what you call a treaty country. But other than that, it's federal reciprocating countries. They're all kind of like treaty countries. Federal reciprocating countries are countries, and there's only a half dozen that have agreements with the U.S. to do child support practices with each other. But again, the Hague Convention countries are the biggest block of countries that use the Hague Convention procedures to refer and receive cases.
Okay, great. And then Danelle had asked a question early on, which is, if folks move to other countries, are they just out of the picture? And I feel like the short answer is no. There's absolutely reason to believe that for a lot of the countries, child support can still be collected. It's just a little bit more complicated depending on where they are.
That's absolutely correct. So we have to know what country they move to, whether we do have an agreement that allows us to send a referral to that country to establish paternity, child support. Right now with Mexico, as you mentioned, right now we're working on a grant work group with Mexico and Canada. And right now with Canada, it's simply refining processes we already have. With Mexico, it's just trying to enter into very basic agreements where we can send referrals and receive referrals from Mexico. So that one is still months away probably from having any type of a practical application. However, I would encourage anyone who has a client with the non-custodial parent who has gone to Mexico to go ahead and see if we can do anything right now. If you have, I don't know that you get referrals from custodial parents who are in Mexico looking for support from a non-custodial parent here in the U.S. Doesn't seem to be something that would be the source of your cases. But if you do, we actually can establish the obligation of somebody who is in the state of Washington, or if in the United States and the custodial parent is elsewhere. Any custodial parent outside of the United States can submit a direct application for child support services. And again, it's like you may run into this. You may have international links, people who are asking you how they might go about it if you have a custodian in another country. And it doesn't matter what country they live in. I've actually seen them with a custodial parent in China, who we have no agreement with, submitted a direct application for services. We will provide services to any custodian anywhere in the world who submits an application for services. There may be other issues, such as how do we get payments to them, but we will provide services.
Okay, great. And Mary's asking a great question. What should we know if the NCP is in the U.S. Armed Forces? Anything specific about that, Tom, that you can share?
Thank you for your service, and thank you for being subject to garnishment like every other citizen. They can proclaim the protections of the Service Members Civil Relief Act, if I've said that correctly, which may delay establishing an obligation. There also, it is really difficult if they are stationed out of the country. But it's rare that we are not able to get an obligation established. Depending upon their specific circumstances, it can take a significant amount of time to establish. Once we have an order in place, collections are actually not much of a problem.
Okay, great.
And it's actually Civil Service Members Relief Act. It used to be soldiers and sailors.
Yeah, so thank you for that comment. Danielle's concern says that we have clients whose spouse was deported and they become concerned that child support will be placed against a spouse who is residing in Mexico. Have you heard of that, Tom?
I want to make sure I'm reading it. Client whose spouse was deported. I am presuming by the question that the spouse who was deported was the person who owed or owes child support. So yes, child support, we would see child support against the spouse in Mexico, or maybe I'm confusing, or need some clarification on that question.
Yeah, I think Janelle is in a different position so it's not, he's not an advocate, but instead they're a CSD worker. And so I think so I'm not sure if domestic violence is at issue here.
Actually, I think if you're saying that the caretaker who is not the mother, somebody other than a parent has custody of the children and applied for TANF, yes, we will attempt to collect child support from both parents. Unless there's some reason that unless there's a legal reason, we would not attempt to. A parent who has gone to Mexico is pretty much safe from us at this point, but that's what we're working on with Mexico, to try and increase the likelihood that we can collect from somebody residing in Mexico.
Yeah, and for good cause, it's just good to remember that the thing that triggers or enables good cause is concern for the fear and safety, or fear of the safety of your child or yourself. And so there are lots of folks who don't want child support for a variety of reasons, but if it doesn't rise to the level of concern for the safety, it probably won't be granted. So there's other, I think, advocacy strategies to do with those folks to make sure that they're doing okay. So this is a new slide that Tom just wanted me to remind folks about, which is that, young folks that become mothers, if their pregnancy was a result or an evidence of sexual assault, just as a reminder that state employees, just like domestic violence advocates, are mandated reporters. And so it is reported to law enforcement and DCYF. And if TANF then is, granted, child support can also be triggered. So just, again, young folks might not be thinking about this. It's just good to know that if you're working with a young mom whose maybe experience was this, or even if not, and she's on TANF, it's just a good reminder that a child support case can be opened. So I think we did it. I think we got to the end of most of our content. These pugs want to know if you have any questions or comments. Anka's wondering, in what situations does DCS close a case? Do you want to go through those that beyond the good cause level A, I assume?
You just made my brain hurt. There are many reasons a case can close. All the way up from the non-custodial parent paid all the child support they owed. One of the parents has died, and there is then a Washington order will die along with the death of either the either of the parents. Some court orders actually will, last longer than the death of a parent. Could be we lose contact with non-custodial parent or the custodial parent. And that's actually something that's a good thing to keep in mind, is that because custodial parents, your clients, may not have stable housing, we only have to lose contact with them for 60 days before we close the case, which is kind of ironic because the reason we usually lose contact with a custodian is that they have moved and not shared an address with us. And so if they are really hoping to get the child support, they have to remember to keep us updated with their address or contact information. But I'm trying to remember, oh man, a whole bunch of different reasons cases can close. There may be bases, or I guess to lump them in groups, it's like if the non-custodial parent cannot be found or is determined to have no ability to pay, they're permanently, totally disabled. If their sole source of income is supplemental security income, those cases can be closed. A non-assistance case, the custodial parent can ask us to stop collecting at any time. That brings up the cases where if there is debt owed to the state, the custodial parent can only ask us not to enforce support that is ongoing and due to the custodial parent. On interstate cases, if another state refers a case to us, we can only technically close that if the other state gives us permission to close, which can get interesting if we tell them that there's no way for us to enforce an order and they still won't agree to let us close the case. And I know I'm forgetting a lot. There are just a whole bunch of reasons that child support can close the case. I guess touch one other that just comes to mind is that if we have been unable to collect the child support and the child support debt when the statute of limitations comes into play, then we would close a case at that point as well. Statute of limitations in Washington is the 10th year after the youngest child on a child support order turns 18. So it's the 28th birthday of the youngest child on a child support order. And as simple as that may sound, it can get a little more complex. Collecting support from incarcerated parents. Incarcerated parents may have accounts with the prisons that they are in that we can garnish. It's usually no more than a few dollars a month. Sometimes incarcerated parents will contact us, and a relative may actually make arrangements to pay some small sum each month if we will leave their inmate accounts alone. And we will accept that because, again, that's rare, but we will always work with somebody who can get a friend or relative to pay some small amount rather than hope we might attach $10 or $15 from somebody who's in prison. We can collect even incarcerated people who may have worked within the last year or so, might have tax refunds coming in. So it's like if they have any assets that anybody who is not incarcerated may also have, we can attach those.
Great, I didn't know that.
So it's difficult. They have to have something for us to attach, but if it's there, we will attempt to attach it.
Okay, great. Well, hopefully that answered the question. I'm going to move on, but feel free to continue to put questions in the chat. I wanted to make sure that you all had Tom's info because, again, he knows all the things, and he knows a lot of things that I just really don't want to know. So I just appreciate you holding all that info, Tom, and is willing to share it with us. So thank you for that. So that's his info. And again, you'll get a copy of this presentation. The other thing I wanted to share with you is that we have in our state, we're super lucky that we have this great group of folks that you can see that we gathered like days before everything shut down. We did not know what was coming, but we gathered in March of last year, and these folks are special folks who are committed to being sort of the DV expert in their child support offices. So we've got folks in every single office. There are 9 field offices in Washington State, and there are DV liaisons in each of those offices. Sometimes there's more than one. And those are a great group of folks. So if you're struggling, or if you are working with a particularly challenging child support issue and you want to get connected with the liaisons, just let me know. I'd be happy to connect you with the person in your office. It looks like we've got a question from Anka in the chat that is wondering if a case is closed because the NCP was not located or they lost contact. The child support is still accrued, right? And are there time limits, amounts to reopen the case? My understanding is yes, it's still accrued, but I don't know the answer to the last piece of that question.
Yes, if there is a child support order in existence, that order continues to accrue, keeps on ticking away until the child is emancipated. If we have not established an order, there may be time limits that we can go back once we do locate the non-custodial parent. And that depends on the circumstances. And the time limits to reopen a case, yeah, you are restricted to asking for reopening for as quick as you are at submitting an application. I would not suggest, if we tell you we're not going to reopen, but it never hurts. If there's something that happens where you know a non-custodial parent has gone to Mexico, and you find out even 6 months down the road that you know through contacts that non-custodial parent has moved back to the U.S., regardless of where in the United States that non-custodial parent may be, because we can refer to other states as well, you can absolutely ask us to reopen the case.
Great. Okay. So another thing I just wanted to remind you that we have all these great resources, including like TANF 101 stuff or anything about public benefits you can find on our Economic Justice Project page. You can also just go to wiscative.org and put in the search bar whatever you're looking for and see what comes up. We've got tons of resources that we've done in the past, and then also new things that we're doing all the time. Similarly, keep coming to these webinars or trainings. I've linked the calendar, lots and lots of offerings coming soon. We have a question in the chat about if there are folks that can help people with parenting plans and custody cases. That, you know, we have a legal advocacy project here at the coalition, and so Heather is in charge of that, and I'll put her info in the chat as well. But there, you know, legal advocates at all of our DV programs can be super helpful. And then a lot of those programs have relationships with civil attorneys who can help with parenting plans and custody.
Eileen.
Yes.
Does Wiscative have a relationship with the Washington State Bar Association? Or would that be something that the person you just referred to would have a link to?
Yeah, I think we're connected. I don't think we necessarily, you know, we don't have a staff attorney or anything like that. But if you want to connect us so that we have a stronger relationship and can get folks attorneys, that's always appreciated.
Well, yeah, I don't have a connection, but you can always contact the Bar Association because I'm pretty certain that they keep track of attorneys who put themselves out there for a pro bono or even reduced rate support services. They have a family law section, and they would no doubt have a number of attorneys who are well aware of child support, of domestic violence dealings while they're working on support and custody and visitation.
Yeah, for sure. And folks are putting resources in the chat, including the Northwest Justice Project, certainly. And then if you're not familiar with Washington Law Help, they have a lot of information that's just in a very readable and understandable format around, parenting plans and filing for dissolution and things like that. So, and then, last thing is that I really hope you stay connected. Tom has been gracious enough to spend these 2 hours with us and is also gracious enough to answer our questions. So, certainly reach out to me and I can connect you with whoever you'd like, at Wiskative or, in DCS field offices. And, we just love seeing and hearing about the work that you all are doing and making things better for folks all around our state. So I just want to appreciate you one last time before we go. I think you're awesome. I think the work you do is so important. I hope you're loved and appreciated by everyone around you and that they bring you treats, especially today after sitting through this very dense webinar. So please do keep in touch with me. You can always call or email, and we're here for you.